Hello, we are here to talk about standard essential patents. That means patents that apply to a given standard. And I'm here with my partner Johannes Heselberger, and we would like to go over the issues of litigation, licensing in that respect. So Johannes, standard essential patents, how does that all come about?
In certain industries like the telecommunication industry, and many more will follow soon, certain technologies have to be standardized in order to be compatible, in order to be usable in real life. And that means inventions, or sometimes only definitions, which are patented, have to be used by a market player if he wants to play in the market.
So this comes by success, because I'm successful in the market.
By success or by sometimes technical needs. A certain filler cap needs to be matched and so forth.
But the standards that are set by the organizations, there I have to give a commitment, because I invented something that reads on the standard, it's made part of the standard, so everyone has to use it. So I have to give a license commitment.
Yes, that's the FRAND commitment, as many term it. That does not exist with de facto standards, obviously. Now, our courts in 2009, I believe, started dealing with such essential patents, standard, defined standard, or de facto standard essential patents. And the landmark decision in those days was the so-called Orange Book standard decision of our highest court, the Bundesgerichtshof, Federal Court of Justice. Under that Orange Book scheme, a user of a standard had to apply with the patentee for a license. He had to make him a more or less fully formulated license offer. He had to deposit money for past use and had to regularly account for future use.
But then the court in Duesseldorf, Landgericht, first instance court, referred a case, ZTE Huawei, to the European Court of Justice to understand whether Orange Book is really the right way to deal with it. And what happened then?
They essentially turned the whole scheme around. It was now and is now the patentee, the owner of an SEP, who has to make the first steps. There is then a ping pong, some also call it a dance, which has to be followed by the parties. The ping pong starts with the patent holder informing the user of his patents and of his allegation that the user is using his patents when implementing the standard. The user then has to come back with a clear sign of being a willing licensee, and the next step is then that the patent owner offers a license. There can be one further step, namely the user may make a counteroffer. If both offers of the patentee and the user are FRAND, then no injunction can issue. If only the patentee's offer is FRAND and the counteroffer is not, an injunction can issue.
But that sounds easy for litigation. I start the case, I say, here's the standard, you make use of it, it's your burden to prove that you don't, and here's a license agreement. So the court only has to look into the license and determine whether that's FRAND or not.
Yeah, but what is FRAND, Peter?
So not so easy.
I think not.
So FRAND is the question, is the royalty and the terms that are asked for, is that really standard? Is it non-discriminatory? Is it fair on the parties? But having negotiated many license agreements, we know there's not an easy answer if we don't have a standard end-user license agreement for software, for example, where you just have to take it or you don't take it. So the courts have to do quite something to come to a conclusion here.
The courts are indeed in a very challenging situation. Our courts have accepted the endeavor to deal with all questions around FRAND in litigation which is brought to their desks. It is certainly due to our procedural law that one has to go through those issues step by step how, for example, comparable license agreements are disclosed, what the requirements to NDAs in that context are, and so forth. So many hurdles to overcome before one really gets to the core of the issue, namely, what's the right price and what are the right conditions.
But compared to US courts or courts in the UK that have plenty of time to get their arms around those issues, isn't that a challenge for German courts to deal with all of that?
That is certainly a challenge. Now, on the other hand, our courts are developing the rules step by step, which leaves the parties more room to maneuver. They do not have to set a certain price as to what they consider FRAND. And that's then an upside for the German courts.
But it sounds like parties should consider alternatives, like mediation or arbitration, where you try to find an alternative way to resolve the dispute and maybe even ask the court to stay the procedure. Is that happening?
We don't know yet for sure. What we do see is that parties think about mediation, think about also arbitration. There's many points to be resolved, not the least who can properly mediate and arbitrate in such proceedings. But that should be an alternative for willing parties to find a way out of their conflict.
Thank you very much, Johannes, for the explanation. A very challenging topic, and you cannot start early enough with your consideration and communication to deal with the issue.
Yes, absolutely.
Thank you.
Thank you, Peter.
Thanks.